We are fortunate this afternoon to have three individuals who played a very key role in one of the most fascinating recent settlements, on a par with the Gulf oil spill, I would say, in terms of scope and unique features. And that's the Volkswagen settlement. And Seema Caccade of the University of Maryland Law School, who was involved in the matter when she was at EPA in the enforcement office and is doing some interesting writing about it, is going to give an overview. Then we're going to hear from John Cruden again, and you can't get too much of John. He has some observations, and guess what? He's also authored another law review piece on this. I'll give you the site after they talk. And David Nachman, whose name was bandied about quite a bit earlier, he's a senior enforcement counsel in the New York office of the Attorney General, also played an important personal role here. So Seema will begin. Thank you for coming, and we'll look forward to the panel.
Sounds good. All right, can everybody hear me? All right, wonderful. Well, I know we are running a little bit late, so David, I'm going to try to make up a little time and go through my slides and give an overview on what this case is and what it was about and some of the maybe unique features. And I'll do a little bit as I'm going through of a contrast of some things that were present here that were different than some of the earlier panels that I think are really important to kind of highlight. All right, so I'm going to quickly go over the regulatory background, so what world we're dealing with here, what statute we're dealing with, VW's violations, and then what we mean when we say the VW settlement or settlements. And then I'm going to focus on one in particular because that's really where the environmental and health benefit component comes up. Okay, so what we are talking about is cars. We're talking about passenger cars owned by Volkswagen, and we're talking about diesel cars. And we are also talking about the pollutant NOx, nitrous oxides, which is a pollutant under the Clean Air Act. What we're talking about with respect, sorry, I think someone earlier had this issue. I'm going to scoot around. What we're talking about is the mobile source provisions of the Clean Air Act that require manufacturers of cars, like Volkswagen, to apply for a certificate of conformity. And the certificate of conformity, or COC, what it does is it actually says that these vehicles of a certain model year comply with the NOx standards in this case. So EPA issues COCs to manufacturers on a regular basis, and those COCs are based on the applications from the manufacturers themselves. So what happened here was the COC did not include any information about what's called a defeat device. Some do, because some defeat devices are okay. This one did not include it, okay? What's a defeat device? Defeat device is anything that basically disables the emission control system in the car. So here what happened is VW put in a computer algorithm into their cars that effectively took off the emission control device when the car was what's called in use, and tricked the computer system tricked the car into understanding when it was in a test mode, and it operated differently in a test mode. So that was the difference. We've got the test mode where the filters or the emission control system is running, so the inspector says good to go, but when it's in use, it's not running. So what happens is you're resulting in excess NOx in the air coming from those filters. Lack of filters is what actually was the case. All right, so let's go to what VW's violations were. The notice of violation and the complaint, this happened pretty early in the summer of August 2015. What we have here is VW actually admitted this problem, that they had defeat devices in their car, undisclosed defeat devices. And so what we have different than maybe some of the other cases we talked about earlier is an admission from the company in this case. And we ended up, the EPA sent out the notice of violation pretty quick after that. It was, hit the newspapers pretty quickly. VW stock took a big hit this summer and early in fall of 2015. And the Department of Justice, I think, filed their complaint in January 2016. John can correct me if I'm wrong on that date. So what did the complaint allege? We've got about 600,000 diesel cars that had these computer algorithm systems in them that made the cars operate differently in use or normal operation mode rather than when they were in test mode. The third bullet here, specific in the complaint, it was that these were prohibited devices under the Clean Air Act, which the Clean Air Act disallows. And most significantly for purposes of this conference, an allegation that the cars emitted excess NOx. All right, the settlements. There were 3 major settlements that resulted pretty quickly after the complaint in January 2016. You'll see up in the slide that consent decree was first lodged, actually, I think in June of 2016, so less than a year after the scandal broke, which was August 2015. And the consent decree was entered in October of 2016. This was with regards to what's called the 2-liter vehicles, so a subset of the total diesel vehicles that had this computer algorithm and defeat device in them. So this first settlement, the first partial settlement, covered just the 2 liters. The second settlement is the 3 liters, so it's this different group of cars that came later. I have them renumbered here because of the dates of lodging and entry. The second settlement is actually the 3-liter settlement, even though the entry date came later, so that's why I have that done. It's often referred to as settlement number 2. Settlement number 3 dealt with civil penalties and injunctive relief to prevent future violations. So the first settlements, the 2-liter settlement and the 3-liter settlement, were purely injunctive relief settlements, okay? The civil penalty didn't come until later. That distinction is important for something that people have referred to a lot here, which is supplemental environmental projects. In EPA parlance, supplemental environmental projects are discounts off of civil penalty. Okay, so when I'm going to talk about the 2-liter settlement here, when I'm talking about the environmental benefit, they sound like supplemental environmental projects, but the authority actually resides in injunctive relief. So that is a little bit of a distinction that I think is worth noting here. There are a few additional settlements that came. I'm not going to go into a lot of detail, but just to give some context here, as John mentioned earlier, there's often criminal cases involved in some of these cases. VW was no different. As you can imagine, there's outright cheating going on. Customs and Border Protection also resolved civil fraud claims, so there are multiple agencies involved in this settlement as well. You'll see in the third bullet, Federal Trade Commission was heavily involved in this process, particularly because there was also a class action settlement. There were consumer-related damages related to marketing that were involved. So John, maybe David will talk a little bit more about those settlements, but that is sort of general context for all of the other players that had a really big role in additional settlements that sort of were part of the overall VW package. Okay, what I'm going to focus on is the 2-liter settlement, again, because this is where you get your brunt of the environmental and health benefit. So the partial 2-liter settlement had 2 major components to it. The first was what we refer to as the buyback or emission modification. That's get the cars off the road. Figure out what to do with all of these diesel vehicles that are on the road and continuing to pollute above compliant levels with respect to NOx. NOx is one of those pollutants. If people are not aware, NOx is a pollutant that travels very quickly. It's the Clean Air Act can be very difficult, and the main reason is because you can't actually see the pollution that you're dealing with. It moves, it transforms in the air, it mixes with sunlight, it mixes with rain, so it can be really hard to figure out how to deal with it. It is truly a public health issue. NOx has tremendous health benefits, tremendous natural resource impacts too through acidic rain. So there's a lot of issues going on with NOx. But what we knew for sure, were cars that were in excess of NOx on the road, and they needed to be taken off. So I'm going to tell you a little bit more about the buyback or emissions modification element of the 2-liter settlement. The second big part was to deal with the environmental harm. Okay, so I'm going to talk a little bit more about that. And when we think about what was the harm from these violating vehicles, the harm element is, this settlement really identifies it in 2 pieces. One is the NOx that I keep talking about. The other was a different kind of notion. The other was a notion that we've got a lot of people who actually purchased Volkswagen cars thinking that they were buying green vehicles. Indeed, Volkswagen marketed these vehicles as being green vehicles, and many of the consumers that bought them perhaps would have bought an electric car, perhaps would have bought a different type of vehicle that was truly green. So the environment has suffered even more because there likely would have been additional truly green vehicles on the road. And this was a huge part of sort of the consumer issues that were coming up, the advertising that VW had done. And so we really focused in a lot on the marketing and the green claims that were attached to some of these diesel vehicles. All right, so the first part of the settlement, the buyback or emissions modification. VW was required to get the cars off the road. Okay, so they either had to offer to buy back cars, okay, and they could fix them. So there was an emissions modification provision in the settlement that allowed the company to come up with a fix. So if you had bought a diesel vehicle and you brought it into your dealer as a part of the process, and VW was approved to actually fix it, they could go ahead and fix that car. If there was no emission modification that had been approved by EPA and CARB, California Air Resources Board, then that car would have to be scrapped. But everybody was able to get their car bought back, and there was a whole formula done for fair market value of that car, which was a big part of this settlement. To date, I think several different types of 2-liter vehicles have been approved for emission modification. So VW has gone through that whole process. And this was a pretty monumental task if you think about trying to get all these cars off the road. I mean, there were major, having to bring cars to sort of holding areas, figure out if the emissions fix was going to be approved. So all of that had to be built into the settlement of exactly how this process was going to go. All right, on the environmental harm piece, remember I said that there were 2 parts of the environmental harm. One was dealing with the NOx. Okay, so that's the part that this slide is referring to, dealing with the NOx. The way we dealt with the NOx in this case was to set up a trust. Okay, this was called the mitigation trust. And what this does is it's a huge chunk of change, $2.7 billion. Okay, it was allocated to pretty much all it was allocated to the states. There was an amount that was allocated to the tribes. There was an amount allocated to territories. So each, I'm going to just refer generally to states though for this purpose. Each state got a certain amount. The allocation was done primarily based on how many violating vehicles that state had. So if you had more dirty vehicles floating around in your state, you got more money. Okay. Now the states, in our case here, different than some of the other cases that were discussed earlier, could only spend their money on specific kinds of projects. So it was dedicated funding. They had 10 choices of different types of projects, things like school bus retrofits, things like going to your port and swapping out some of the big cranes that unload the bananas if you have a port. A lot of these things are heavy duty on diesel. So the idea was that we were going to really clamp down on diesel emissions from large sources of diesel across the United States. So that's what the 10 eligible projects were and still are. What's happened as a result now is that I think a lot of states, and some of you may be able to talk about this in the Q&A, a lot of states actually have gone out and asked citizen groups, asked folks in their own state, come tell us, what should we spend our money on? We've got 10 options. Should we do more on option 4, more on option 5, a little bit on all options? And so, for example, I know in Maryland, they've gone out with a decent amount of public involvement to try to figure out where they're going to spend their money, and I think that's happening across many of the states. Couple small little notes here is that the 3-liter settlement, which I talked earlier about as well, also had a certain amount of money that went to the NOx Mitigation Trust as well. The trustee here is actually a bank, a private bank, Wilmington Trust. So there was a whole process involved with setting up the private bank as being the trustee here. So that's a sort of an interesting element of this case as well. And then back to the buyback and emission modification process, VW had to meet a target for their recall rate. They had to get a certain percentage of the cars actually off the road. We couldn't guarantee that everybody would bring back their cars. Some people would probably choose to keep driving them. So they had to meet a certain recall rate, and if they didn't meet that, they had to pay additional money into the NOx Mitigation Trust Fund. That's how that worked. This is a sort of just a quick slide that NACA and NASCIO, 2 state agencies that work on energy and clean air, have put together that gives you a general idea of the NOx Mitigation Trust Fund. So you can see on the US map, the darker states are the ones that got more money, corresponding with the orange bars over on the right-hand side. So you can generally see which states had more polluting vehicles. They were generally the ones that got more funding. And then there's the purple tab at the top is just to give you a sense as to regionally, based on EPA region, what are you looking at? All right, and then the last piece on the environmental harm, dealing with the fact that there were a lot of people that actually really wanted green cars and didn't get them. What VW had to do in this case was invest in electric charging equipment, electric charging stations. Okay, so this is what's referred to as the ZEV component of the settlement, of the 2-liter settlement, zero emission vehicles. So they have to invest a pretty sizable chunk of change of their own money, and they do that through a process by which they have plans on where to put additional charging infrastructure across the United States, and that plan needs to be approved by EPA, and they're doing that over the course of many years going forward. I think 2 plans so far have been approved on where they're going to put charging infrastructure. So that's generally the overview on the VW 2-liter settlement. John.
So it is a treat for me to have both Seema and David. Seema, who is uniquely involved in EPA, David, who is really our leading lawyer of the states. I'm going to largely, David, defer to you on the state issues there, and try to bring you back to where I left you when I was giving you some of these points that I thought were important as lessons learned out of the BP experience, and try to apply those lessons learned here and see what's different there and whether or not that works or not. At the outset, let me say one big thing that characterizes all that. When I was talking to you about BP, I was talking to you about an accident. 11 people died, 40 people injured. That was an accident, and that affected how, as Department of Justice, we brought this case. This was not an accident. This was an intentional act, and that will impact virtually everything I'm telling you about. So I am in my office. It's 2015. We have pretty much got the guts of the Deepwater Horizon consent decree together. We're still working through the EIS when Cynthia Giles called me and said, quote, "You're not going to believe this. Volkswagen." Well, come on. Half of us, probably maybe all of us, grew up with Volkswagen. Come on, I had a Bug and all those things there. So, it was thinking new right then there about this case. All right, so I told you one of the things is you really have to understand the MDL process. Just about the time that Cynthia Giles, EPA, SEMA went public on NOV, the world opened up with litigation. Cases filed across the United States there. Same thing I told you before. You really have to understand that the MDL panel is very powerful. They pick the jurisdiction. In this case, it was San Francisco. They picked the judge, in this case, Breyer, whose brother, of course, is on the Supreme Court. There. So right away, the civil case is in San Francisco. Simultaneously, we're not public about this at that stage, we are running a criminal investigation, but we're running it out of Detroit, Michigan, for the perfectly good reason that they understood cars at that stage. So right away, you have two different places. You have a civil case in one jurisdiction, a criminal case in another, and you have two different groups inside of justice that are working on that. You have a civil group doing one thing, you have a criminal group doing another, and there's a whole number of rules associated with what you do and what is called parallel investigation. So the first part is MDL, once again, extremely important. And again, one of the reasons why we filed as soon as we could is we wanted to be part of the MDL process. Without question, the experiences of Judge Barbier and how he put together Deepwater Horizon had an enormous impact by us, but by everybody else, as to how the case was put together in San Francisco. So you're litigating simultaneously, and you have a settlement. And we had two different teams doing that. There. So that was another lesson learned, is you really have to have two different teams because the only way these things work is, in fact, that you are pursuing litigation fairly strenuously at the same time that we're having simultaneous settlement negotiations. Parties, remember I told you got to figure out who the parties are right away. We refer that, Seema and David and I refer to it as Volkswagen, but it was more. Volkswagen and the engines involved, some of them drifted into Porsche, and some of them drifted into Audi. And so right away, we are bringing our case against all three of all of them. The people that I met in my initial meeting with Volkswagen, 3 weeks later when I had my second meeting, none of the people who were in the first meeting were in the second meeting. They had all been fired or suspended. So they moved up, essentially they moved up the Porsche leadership, including CEO and general counsel and everybody, into Volkswagen. Same point though, is critically important when you're involved in that, is figuring out who those are. Who are the players that you're going to be negotiating with simultaneously, as Seema told you, inside the federal government, there are multiple players coming on and adding players as, in fact, we find other allegations of misconduct. And so the player aspect that I told you about in Deepwater is really applicable here, and it changed. And it changed, people involved changed as we were negotiating there. I told you that we had in Deepwater, we had experts on financial abilities. I assure you, we had experts here, experts that we did not expect to testify, but experts who could go and talk to Volkswagen so they could open up their books. So we had some idea where they were going, some idea of how they borrowed money, some idea of their bonding process. All of those things were relevant to us because, once again, just like I mentioned for Deepwater, it wasn't that we were trying to put Volkswagen out of business. We just wanted to make sure that we were addressing the following points. What did we want? Number one, there was ongoing pollution. We were estimating at that stage that the NOx violations, carcinogenic pollutant, were 40 times higher in some instances for the cars that were on the road than what it should have been the standards. So everybody driving a car is driving something that's polluting as much as 40 times higher. So that was a priority. We told the judge, this is our first priority, is cars on the road. Second, how do you make the environment whole? How do you do that? Well, those are the trust, in fact, Sim was already told you about. So that is how you make the environment whole. How do you, in fact, deter people? That's the penalty that you get. But there's a whole other aspect, way more significant in the context of Volkswagen than it was in BP. Volkswagen is, how do we make sure those things don't happen again? So inside of the third consent decree they were talking about is a whole series of provisions that talk about how the company is going to have to change their internal management, how they're going to proceed, how they're going to report things, how they're going to train. All that is inside of that consent decree to make sure that these things don't happen again. So those are the things that we're thinking about from the very outset, and the things that we are presenting to the company at the very outset, saying, we're not giving you numbers right now, we're telling you conceptually what you're going to have to do to be able to settle with us. It is complicated in these sorts of cases that in fact there is a parallel criminal case and a parallel civil case going on at the same time. Ordinarily, under Department of Justice policy, when you have these parallel actions, the criminal case goes first. But the exception is if there is environmental consequences, ongoing health issues, ongoing environmental issues, that's an exception. And so that's what happened here. You have ongoing pollution, so those first two consent decrees, Seymour, we're talking you through, were all designed to reach that issue of getting polluting cars off the road. And so that's why they went first. The third consent decree that she has went simultaneously with the plea agreement. And so there's a criminal penalty, there's a civil penalty. It also sets up independent monitor. So to make sure that the plea agreement is complied with and the civil consent decree is complied with, it sets up a third-party independent monitor who's making public reports and going to the judge as well, saying, the things that were agreed to are actually happening. And by the way, that's ongoing right now. But it becomes more complicated, obviously, because there's all kinds of rules, grand jury rules, and those things that are associated with that. I get asked countless times, in this case, what kind of impact does it have that this is a foreign company? Remember, BP was a foreign company too, but it was more significant in Volkswagen because we had to translate so many of the documents that we were getting. And at the same time that we were there, Volkswagen had a law firm doing their own independent investigation, which we were also getting reports from. Some 40 countries ultimately brought actions of some sort of another under Volkswagen, but primarily, of course, this is Germany. 20% of Volkswagen is actually owned by the state of Lower Saxony. And so they are completely different. Imagine it'd be like 20% of GM being owned by the state of Michigan. That's the equivalent that you have. And they have a board of directors. Actually, they have several of them. And so in the negotiations, all of that has to be taken into account. Again, my point being, those are the things that you're trying to figure out as you do it. And I'm asking the other side, when we agree to something, who is going to approve it? And how long will it take? Because we're trying to move these things along because, again, we have cars on the road. In the case when we brought the final plea agreement, we also brought indictments against 7 individuals. There have been a whole series of indictments. I left in the federal government in January 20th of 2017 because there was a new president there. So we did all that we could at that stage. And to this administration credit, they've been doing more, and there's been more indictments since that time, including the former CEO. However, shocked me, the United States does not have an extradition treaty with Germany. And so that means that unless those individuals, and I'll tell you a story in a second, unless those individuals come within the jurisdiction of the United States, if they stay entirely within Germany, they're protected. Now, several of the individuals were already in the United States when we brought our case, and we were able to take them right away. But here's my story, and then I'm going to pass it on to David. It's another lesson learned. David asked me to have a lesson learned. There's a lesson learned that comes out of this. And so it was right around Christmas time of 2016. And one of the senior engineers out of Volkswagen, who was clearly involved in all of this, decides, after we had interviewed him in Germany, decided that this would be a good time to visit my condo in Miami. Now, if you're a lawyer advising your client, you might tell them, you know, when you put your passport down, things happen. People read that. So we missed him coming into Miami, but we were waiting for him at the airport when he came out of Miami. We arrested him. We took him to Detroit. He's been tried and got 40 months in jail. And so my point is there is the individual issues, both complicated, but it's part of the mindset of things that happen in those cases, particularly when you have this element of intentionality that's there. Let me end as I did. I'm going to pass it to David. Remember, same thing I told you before, in the federal government, when you have these cases, you have public comment. Each of the consent decrees that SEMA told you about went out for public comment. We got 100,000 comments on the very first one. Less on the second one, less on the third. But my point is, once again, that process alerts the public, gives them information, gives them an opportunity to participate. But when the judge, in this case Breyer, approves it, it becomes a judicial order and way more powerful. There's no possible way we could have done all of this without states. California Air Resources Board played a critical role, but without question, so did the state of New York, who led that effort, and David led the part in New York. David?
So it's very nice to be here, and it's very nice to be welcomed by John and SEMA. I will tell you candidly that during much of the negotiations and process leading up to it, I don't know that the welcome was all so warm. The point is that historically, mobile source emission cases had not been the province of the states, with the limited exception of California for obvious reasons. Under the Clean Air Act, California has special status. It is and then under Section 177 of the Clean Air Act, individual states can choose to adopt the California standards and enforce the California standards as if they were part of their own law. But that's limited to those 12 or so states that have adopted, who have taken advantage of the provisions of Section 177. Volkswagen, and as John correctly points out, actually, the defeat device started at Audi, as it happens. It was first engineered there and then migrated to Volkswagen, but they're all part of the same corporate family. Volkswagen is not the first diesel cheat case. There were basically large truck cases in the past, but historically, those didn't have a significant consumer protection element. They didn't involve a company mass marketing a vehicle to the public based on the green qualities that SEMA pointed out that Volkswagen did very much so here. They even had a Super Bowl ad, which is hilarious actually, touting the green aspects of their cars and so on. So immediately, even though the states historically had not played a role in these vehicle cases, it was just too much a flagrant, notorious issue of public deception for state AGs, who are, after all, are elected officers in most of the states, to ignore. And they were determined to get involved in it. And the first point of entry really was the nearly consistent, uniform consumer protection laws, commonly known as UDAP laws, Unfair Deceptive Act and Practices statutes, that are virtually uniform across the country, that allowed the states to enter in, commence investigations, serve what are called CIDs, civil investigative demands, or here we call them in New York subpoenas. We like the traditional language. And really begin to quickly develop the facts. We were determined to vindicate state law with respect to Volkswagen's conduct. This is an unusual case in many aspects, in every aspect. The relief that the federal government was able to accomplish was truly extraordinary and transformative, so much so that there are business school articles written about the ZEV program, which has really launched a whole new business with all sorts of interesting complications about whether Volkswagen is using it to advantage its vehicles on the road. And there's all sorts of interesting policy implications that grew out of this. But I want to focus on process a little bit more. So the states wanted to get involved. And what does that mean? You have 56, really. It's not 50 states when you talk about these multi-state investigations. You have the territories, you have Guam, you have Puerto Rico, you have the DC. So you're quickly above 50. How do states operate effectively, meaningfully in these contexts? Well, they have to get organized. And typically that takes place in the context of a multi-state investigation. And you have all sorts of organizational challenges. It's not like you have just DOJ and EPA. They have their own perspectives, but they usually are able to come to some common perspective. Here you have to deal with the sometimes parochial or self-interested concerns of elected officers, once again. And so a big issue there is allocation and organization. Organization has to do with who's going to be a lead state, who's going to take the laboring oar. That becomes, to some extent, a self-selecting process. Sometimes it's an expectation of a little bump for attorneys' fees and for the effort, but not always, not always. It really, there are free rider problems when states organize. There are states that just, hang back and know that they're going to get the benefit of the work of the others, and that comes with the territory, and it's pretty much accepted. Allocation, you've touched, I think, during the course of the day on allocation issues. We heard it in the last panel. That's a critically important thing. Here, the answer to allocation was more or less self-evident. Certainly from a consumer protection point of view, it makes sense that you would look to where the cars were sold. So if you're going to assess penalties for the violation of law, of consumer protection law in each of the states, you're going to look to how many violations there were, which is roughly consistent with how many vehicles, or that's a rough proxy for the consumer deception. From the environmental perspective, we did also, and I think for the mitigation trust, actually the origins of it is that we didn't use cars sold, we used cars registered. There are some slight differences. A car may be sold. For instance, some states don't have it, especially out west. Wyoming may not have a Volkswagen dealership. They may sell all the cars in Colorado or Montana, but there are cars registered in a particular state. We thought that for environmental harm purposes, and as the mitigation trust ultimately adopted, that cars registered was a more meaningful proxy. Not a huge difference, but we had to sort that out. But the biggest allocation issue had to do with what I alluded to before, which is that the 177 states, those states that had the ability to enforce environmental laws, had a different perspective on this than the non-177 states. They were seeking the vindication not only of their consumer protection laws, but also of their mini California statutes in their state law. So this was new to the states. In part of the organizational challenge was that we were dealing both with the consumer protection side of an AG's office as well as the environmental unit of an AG's office. Frequently, these are people who had never met, didn't know each other. There are two environmental lawyers from Connecticut and Massachusetts here, and who are very important to the multi-state effort. Connecticut and Massachusetts were part of the executive committee. And I don't know about in their states, but in other states, these were people who our effort actually brought together within their own state because they had never previously interacted. Their perspectives on what a multi-state involved were very different. Their expectations of how this would work were very different. And so that itself was a very interesting challenge. Ultimately, the consumer protection case was resolved right in connection. Well, before I get to that, one other point about the MDL. The states historically are allergic to subjecting their enforcement actions to a federal court. States don't like to be, when they're enforcing their laws, in federal court. It happens not to be my perspective necessarily. I think that if you look at the efficiency and the quality of the federal bench as compared to many state benches, I would submit that states ought not to be so reluctant to submit themselves to federal jurisdiction. But that's just me speaking not with the authority of my office or anything of the kind. But the action, you talk about who's in the room, you've heard that phrase today, the action was all around the MDL, the private bar that was representing the consumers in the class actions, obviously the Department of Justice, EPA. In California, California, I think, plays a huge role in any mobile source case for obvious reasons. CARB, together with EPA, are the testers of these vehicles. They're the folks who discover the wrongdoing often. But the states generally did not want to be in the MDL. So how are you not in the MDL, but still at the table? And what we did was simply write to Judge Breyer and say, we're here, we're investigating, we're not going away. And ultimately what happened was that Judge Breyer, who appointed as the special master for this case to mediate the settlement discussions, a fellow who you may have heard of named Bob Mueller, and who did extraordinary labor in mediating this matter. He was just the right person, I think. We were able to participate in those mediation discussions. Again, we were sort of the skunk at the party. It wasn't that Justice or EPA or California even loved us being there, but we were there and we were able to make our positions known and make our claims part of the resolution process. We did resolve on a more or less national basis. There were a couple of outlier states who decided to pursue their own litigations. We did resolve the consumer protection claims right around the time of Settlement 1. But that left unresolved especially the Section 177 states' environmental claims. Those claims, for a long time, they were new, and the federal government, I think, would have preferred, or certainly Volkswagen was of the view that they might be preempted. They realized that they didn't have a strong argument with respect to the Section 177 claims. And in fact, there are a couple of non-Section 177 states who pursued their environmental claims in either state court, one of them in the MDL, or maybe two of them. So far, they have lost those challenges, and those environmental lawsuits by states in the mobile source context have been pretty consistently been found to be preempted. But the Section 177 states were determined to press forward with their claim, and then I'll get to the last point that I want to emphasize about the process. Volkswagen thought, and its counsel thought, that, okay, they settled with the states on the consumer protection, the states are taken care of, they got their penalties, they've got their consumer relief, but they weren't prepared psychologically, financially, otherwise, to really deal with the fact that states who have signed on to this enforcement authority have that enforcement authority, and when they didn't meet our demands, we sued. The suits were and I commend them to you, I think, together with the criminal prosecution, they remain the most detailed public accounting of what actually happened, which gets me to my last point. The suits that we filed named, I think, all of the individuals by name who were subsequently indicted by the Department of Justice Criminal Division. They laid out the sordid tale of the intentional conspiracy that the company engaged in for about a 10-year period. And I like to think that they served an important public benefit. Because when you come back to deterrence, sure, money is the primary means of deterrence. And an important close second are the monitoring and governance changes that were part of the final consent decree and part of the criminal resolution to which John referred. So behavioral reforms, governance reforms. But I'm a little bit of a cynic. If you take the financial penalty, which, by the way, was extraordinary. I mean, Volkswagen in the United States alone ended up paying something close, when you add it all in, to something like $20 billion. You would think, if that's not sufficient deterrence, whatever would be? Well, I don't know. The stock price has substantially rebounded. And has it affected a significant change in corporate culture? I know that's DOJ's goal. I know that DOJ did a terrific job in its monitorship provisions, but I think the jury is out, frankly. as to whether it has affected a meaningful change in corporate behavior. And so the other thing that I would say when we talk about settlements, and this is partly because I come from a trial lawyer perspective, is that a public accounting is an indispensable part of deterrence and avoidance of future harm. It's not just a backward-looking thing. Unless companies know that their behavior will be exposed to public light, unless investigative journalists and the media and a concerned citizenry can really understand how this came to be in its detail, I think that we're sort of shortchanging the public and relying on tools which are not going to get us there. The last point I'll say related to that, and I just want to puncture another, or at least dent another commonly held belief. There was reference, I think, in the last panel, and it's a traditional perspective and it's a traditional device. I think you both mentioned it, that here the trial team and the settlement team were different teams, and that's a very common model, and you see it all the time. I don't believe in it. I like the combination of trial counsel and settlement counsel. I think that ultimately defendants pay what they pay and they agree to what they agree to because of the hammer of, they're rational actors. They look at the consequences, and that consequence is an estimation about what a trial will produce. And if you're on the other side of that table, it really helps to understand what your trial case is, what your leverage is, and that's going to, I think, help you come to a deeper and more meaningful settlement. And that's it.
Great. Thank you. All right, terrific panel. Fascinating settlement with some very unique features. Questions of the panel? Yes, Mike.
So on the Gulf oil panel this morning, John and Billy mentioned this, and obviously David just mentioned it well on this panel. In terms of the the working relationship between states and the federal government on these types of complex cases, what are your thoughts on ways that that relationship works out the best?
So the difference, and there was a key difference, in BP, the 5 states were basically in the case. Those were the victims of the case. Here, as you well know, and as David pointed out, the states were in different places in terms of their legal authority and their legal ability to bring the case. When I negotiated, which I did, Volkswagen, California was at my side for every single negotiation, but because of their unique authority, the California Air Resources Board is a co-regulator, and so they had to agree to it. But remember when I was saying at one stage that when you're doing one of these cases, you're looking at the piece that you have, but you know there's other pieces out there. We knew the state had to be there. We needed somebody like David, you to be leading that effort, and somebody that, in fact, we had some confidence in, and the way we engaged, first of all, was in the mitigation practice, which we largely deferred to you coming out with the formula because the allocation was so hard, and you came back basically with that formula, which we then used there. And then, of course, we marched forward and said, all right, we're going to do our thing, and then we're going to get out of the way there. But it is really critical at that stage to have somebody like you, David, that's leading that effort, and frankly, somebody that we could trust in that confidence, who would be equally active, and could marry up the fact that there was a consumer protection and an environmental action, which was frankly difficult enough inside of the federal government, but we knew in each state you were actually going through that same sort of process.
Other questions? Yes.
I was going to say, in terms of lessons learned, in Pennsylvania, our state legislature went after the $119 million Volkswagen money really hard and finally realized they couldn't get it. So I think they did a great job of tying that money up to prevent what other panels have said. If you don't tie it up tight, the states will take it away from you. And then Another lesson learned, since we're 177 state, we sued Volkswagen on our own, collected $30 million from them, and the state government took all that to general fund. So we got the first one all nicely tied up, the
Right.
second one, they just took every penny of it.
So, I mean, Asima told you, and we spent a lot of time thinking about what we thought was the pull-down. It's like a pull-down menu. You go in a restaurant. Because the whole concept of it, the whole concept is we are bringing the environment back and making it whole. So you make an estimate of NOx tons, you try to translate that to dollars, and then we have that pot of money. Then the question is, how are you going to do it? Well, the only way it worked is to get it out to the states. But the only way that worked is to make sure they were going to use it in a way that reduced NOx. If they weren't going to do that, the whole concept did not work. The other question which you could ask is, why didn't you run it inside the federal government? Why did you create a trust? We thought it was more efficient. We thought it was more efficient, more transparent, and to tell you the truth, better expertise in running a trust. So this one got run outside of, now gets, clearly, there's a lot of consent decree provisions that cover it, but we actually created the trust, and what we thought at that stage, and I still think now, was the most efficient process.
I want to echo that. I mean, we're very grateful for the fact that the federal government recognized, I think correctly, that it was at the local level, or at least at the state level, that people could best determine which projects, which mitigation projects were most appropriate and most sensible and would have the highest return on investment. The one issue that came up, and SEMA led the charge on this, was that they were a bear about restricting the uses. SEMA refers to a 10-option list. We viewed it as extremely restrictive. I think the states initially had hoped that the mitigation would extend beyond to what essentially was diesel retrofitting or swapping out old, inefficient, but it was entirely, I think, diesel focused.
Yeah, I mean,
And we had discussions that were, you know, not pleasant about that. We wanted a more liberal, but at the end of the day, I mean, I don't know, and I haven't monitored, and perhaps Mike can speak to this, whether we're actually able to find, I mean, one of the challenges here, it was a very well-funded trust. So are we able to find enough specifically defined eligible projects that qualify for the use of the money? I suspect that'll be yes over time, but it's going to take some time to properly use all the money.
Yeah, and I would say too, the project list was a bear. I mean, it was, you know, I think that it's a really fine balance between making it broad enough and making it narrow enough so that it's not taken, which I think a lot of people have alluded to with the legislature. You know, and something that John said earlier that I think is also really important is, you know, the role of Congress here. We didn't have a Restore Act. So a lot of this, you know, we didn't have we didn't have natural resource damages. We made up our own trust and our own trustee. So we were using a statute, the Clean Air Act, to try to clean up the environment and mitigate and offset harm that was done from NOx in a statute that is not a cleanup statute. So it was just a very different process here. But I think, David, you're absolutely right on the project list that figuring out that right balance was a really difficult process.
Billy, and then you back there. Billy, you had your hand.
Yeah, I just wanted to, we've kind of talked a couple of times in some of the other contexts about the interrelationship between the government claims and the individual claims. I assume there were a set of individual claims that are maybe still. What is was there any interaction with the claims that you settled on that? And I'm particularly thinking about how that buyback works with, because that's more of an individual's right to go claim that buyback, and how that interrelates to any individual claims they might have against.
So I will not, obviously, we had restrictive confidentiality agreements here, so some of the stuff is picked up by that, but I think I can paint a broad picture, and that essentially the federal government went first. The federal government went first. We negotiated what we thought was appropriate with VW, but before it went public, then the class action private suits came in, and we were quite aware what they were doing. But what it got announced in each instance in these there was joint, and so there was no distance between us and the individual plaintiffs at that stage, but that was a very, very, very complicated process at that stage. And in the different stages of those negotiations, it wasn't clear that we would both be in the same place. But obviously it was in Volkswagen's best interest, and obviously the judge. Remember, what David said is Mueller, who's now became famous for other reasons, was very, by the way, he had to resign. He had to resign from this job in order to run the Russian investigation there. But he was very much involved in all this, and sometimes was the linchpin of putting it together so that there was a comprehensive response. But David?
I would just add that here, although it wasn't foreordained, but in a sense it was. They had to come together because the consumer relief had to marry up with the environmental mitigation, which first and foremost involved taking the polluting cars off the road. And I would just note that in Volkswagen, basically a determination was made that with respect by EPA and CARB, that these vehicles could not be retrofitted, or the software in them could not be adjusted so that they would be compliant. So that for that's not true of all of them, especially the 3 liters, but for many of them, most of them, they had to offer this swap, a new vehicle, or if you're not going to take the new vehicle, then a fat check. So that had to marry up with the environmental relief in a very specific way. And the consumer class action lawyers were dependent on the framework that had been set for environmental terms, but that in this situation actually benefited their clients very happily. It's to be contrasted just with the more recent Fiat Chrysler resolution, which is a smaller case where a determination was made by EPA in which there was a similar multi-state process, but the overall settlement was not nearly as robust, the misconduct was not so egregious, the number of vehicles was smaller, and there the determination was made that the vehicles could be fixed through a software fix. So that determination itself affected the scope of the consumer relief because those buyers were not going to get new cars or a check for the full value of their old car. So all of these things are very tight in this context anyway. I don't know if this extends to, it doesn't extend really in the same way to non-consumer cases like a BP and so on. But here, that relief has to be married up inevitably, I think.
Yeah. By the way, just as one aside, those of you who have tried to sell your used car have some rough idea what it was for us to come out with legal standards as to what your Blue Book value was when you brought it in, and you were going to get paid for that. Just everything you can think of, how many miles, what was the condition, all of those things, we negotiated in order to come up with, a price.
2 more questions. First, back here, and then me, and then I'm going to wrap up, and we're going to get out of here.
This is actually kind of embarrassing given that my work on both, but how was the list drafted? Who drafted the mitigation list? And I mean, I think just what we've been talking about in all of these settlements was sort of the innovation, the difficulty with NRD. What are going to be the projects? When are they going to happen? What happens if later on we realize we don't have enough of these projects to spend all of this money? Is there a reopener clause? And I think the one thing that is always difficult, having sat on both sides of this, is when you're exhausted from the negotiations of the agencies and the states, that extra step of reaching out to the affected community, to the scientists, to the people on the ground who have the good ideas and say, you know what, we've done a lot of school bus retrofits, which some of us already do. That's the case. But anyway, it's difficult to say, you know what I'd like to do right now? I'd like to add 100 more people to this discussion. But I wonder if that's sort of a lesson learned in terms of how can we think constructively at the beginning, both as federal government, as NGOs, as state governments, to say when these things happen, I'm just going to throw PFAS out there as a up and coming issue. Who's out there that we can sort of have the leadership committee that the states have, the MDLs have, maybe the scientific community should be thinking about how do we sort of encourage that as a partner effort when the settlement and litigation is happening, so that, or at least be drafting something so that there are these kind of opener clauses if you're running out of money or if somebody comes with a better idea You don't have to go through the entire CD, redrafting process. You could have something built in. I was just wondering on your experience on that.
So the project list, who drafted it? I mostly did, but what we did really was use agency experts. So as I think most state agencies have as well, is people that know a lot about engineering and science. And we're fortunate that we know a lot about where diesel emissions exist in the United States, and we know that there are huge amounts of sources of diesel emissions at airports, at shipping ports. We know that they exist in the heavy-duty sector with large trucks. We know that they exist with school buses. And so we basically talked with expert after expert that work on diesel within the agency, and we consulted with a lot of the state folks that we were working with as well on where they were seeing big diesel needs. And so that list was generated from a lot of the experts that work in diesel in the program offices. So that's how it came about, I would say. And then we did include a lot of reopeners indirectly. So for example, if a particular state can't use its share, they can't find projects, there is a clause in the consent decree that allows that money to go back into the pot and get reallocated to another state. Now, it remains to be seen whether that will actually happen or not, but that is, pollution, particularly air pollution like this, moves around. And so if one state can't use it for whatever reason, maybe there's a neighboring state that can. And so there are reopeners like that. There's another reopener that allows a lot of that money to go to federal land agencies to be able to use it for natural resource issues that have happened as a result of NOx and acidification on lakes and streams. So there is a reopener that exists there as well. So we did build in fairly decent reopeners.
David, I have one last question that was asked me just as I finished, and I want to give it because I have a very short answer. So I was asked, I spoke to the International Bar Association, 4,000 people came in Sydney, Australia. Well, not all of them came to a presentation on Volkswagen. So I gave basically what you'd heard from Seema describing what we did in that. And here was the last question. The last question was somebody, I can't even tell you what country, and said, there were a lot of other countries out there who wanted action. It looks to us that your $22 billion settlement probably took all the extra money that they had. Were you worried about us? And I said,
No.
no. I had a club.
So let me ask a final question, because I think that last interchange set this up nicely. My question is, the BP settlement, your settlement, are these the last big prescriptive mitigation settlements we're going to see in this country? There are folks who criticize the settlement. It looks arguably more like a law than a settlement. The current law suggests that there are financial penalties for violating the law. And what you guys did, what some would say, is took advantage of freewheeling lawyering and came up with your own solution that this is not the way the law was expected to be enforced. And I think that Jeff Sessions suggested that he's in that camp and peeled off of Harley-Davidson settlement a mitigation component in a different context. In my old world of federal lands, the mitigation concepts have been taken off the table for damage to public lands, for oil and gas operations, et cetera. Or do you think that instead that these settlements are, have the wherewithal and show the way for the future?
So I'm going to add to a point that David made toward the end, and that is, I spent a lot of time at Department of Justice. Nobody settled with us because they liked us. Nobody settled with us because they thought that was a really good thing for their shareholders. People settled because they thought it was better than the alternative. And the alternative was a court making a decision over a period of years as to how you were in trouble for violating the law. everything that we're talking about today in the context of virtually everything you spent today, judges were involved, cases were involved. These are extraordinarily transparent actions that occurred, and this is the classic use of the law. The settlements, for sure, we had creativity. For sure we had that. But those were agreed on settlements. Those were agreed on by the parties, and they did that for any number of reasons. But again, they also thought that the law that they had violated put them at risk financially, probably, maybe, perhaps in excess of what we did in both the BP and the Volkswagen settlement. But I think that's true for everything else that was talked about today. So I think this is the rule of law in operation.
Yeah. Good. Okay. Well, thank you very much. Let's give a hand to our last panel. So I'm not going to keep you but more than a couple more minutes because I know my audience here. Let me mention, I mentioned before that John also has co-authored a piece on Dieselgate, a very long law review piece. It's extremely interesting, called Dieselgate, How the Investigation, Prosecution, and Settlement of Volkswagen's Emissions Cheating Scandal Illustrates the Need for Robust Environmental Enforcement. To his point, his last point. This you can find, I'm sure you have it already, the Virginia Environmental Law Journal, and you've read it, volume 36, 2018. It's a long, really excellent piece. I just want to make a couple of final comments. Number one, I want to thank everyone who's been here and participating on the panel, in the audience, et cetera. I think this has been extraordinarily interesting and informative. It's just what we were hoping for. I'll mention a couple of observations I have. As I mentioned at the outset, our plan now is to write up some observations about these particular settlements. I think we're going to definitely fold in the Childhood Vaccination Act and likely one or two more. These matters are clearly all sui generis on one level. On the other hand, there really are some themes, obviously, that run through all of them, some of them more important than others. But I learned, for example, that we need to have Bob Mueller in our matters. That could be a problem. He might want to retire after his current assignment. But let me just say a couple things. I came into this thinking, first of all, one of the primary questions at the outset on these types of big health and environmental matters is, who is liable? And that's not always an issue. For Volkswagen, it was in spades not an issue. For BP, there actually was a fair amount behind the curtain of liability issues with Transoceans, et cetera, and some other, and some oils, or Halliburton, et cetera, which also peeks into what you often see in these settlements is a three-ring circus that's occurring. We tend to think about the outcome here, but in fact, there's often a lot of activity, a scrum of activity around different pieces of the settlement that then, if things work well, and particularly if you have the kind of affirmative judges that you've had in Gulf oil spill and Volkswagen, that can come together nicely at the end, although apparently they're not always that nice, although David and Seema seem to be getting along now, which is good. And then and then also, to that point, the liability issue, again, sometimes it appears that that's been settled by the time the settlement occurs because of other forces in play. The tobacco settlement certainly feels like that. After many years of victories, they were getting besieged. There was a lot of societal pressure. There are outside pressures that can really change the dynamic involved. That certainly was also a factor for BP, et cetera, when you have a disaster and obvious negligence. And then interestingly, the liability issue cuts the other way for the Vaccine Act, where because of potential liability, companies that made a valuable social product we're going to withdraw from it. So you had to solve a liability from a different perspective. But then the question is, well, liable for what? And this is really interesting to me. I think many of us think that settlements are global settlements. When you're dealing with a problem as big as smoking, or as serious as a major oil spill, or as comprehensive as cleaning up toxic sites, you're going to deal with all aspects of the problem. What we've found out today is no, that's the exception. We're really talking about a piece of it, and maybe a big piece of it, but we didn't hear a lot about individual liability issues. The kind of things that Ken Feinberg talked about at the outset are a different piece of this whole puzzle. We could have talked about it for a number of these matters because there were things going on, and we talked about it some, but one perhaps shouldn't be trying to solve the whole problem. I thought Mark's comments on the tobacco side were really well put. This was an effort to stop smoking, to stop kids from getting connected with smoking, and largely, arguably successful in that, but not so successful in terms of reducing transaction costs for people who are hurt, et cetera, et cetera. And then so liable for what? And also, what's the piece of it that's the penalty? What is a penalty versus what's the restoration? What we're seeing in these more modern settlements is a real component for restoration. And not only the modern ones, but that obviously was the legislated settlement of Superfund, was all about solving a real environmental problem, fixing it. To some extent, that was a tobacco intent that didn't quite get there because of the structure of the settlement as discussed. But we got to think about what were they really trying to do. And perhaps narrowing sometimes the purpose of the settlement may provide you with the opportunity to take that, to achieve that, and arguably set up the corollary, the next FDA involvement, et cetera, the availability of the documents that provide tools for others, et cetera. Again, not one big, happy settlement with a bow on it, but instead part of a broader process. And then, so you've got liable parties. What are they liable for? How do you identify what that penalty is going to be dollar-wise versus the undertaking? And we're all over the map on that. And that was one of the most interesting parts of the day, I think, from the broad cleanup concept driven by a whole new liability scheme that Congress has enacted to a very precise Volkswagen-type recompense for the direct injury that consumers dealt with in buying cars that didn't perform like they expected. Another couple of broad themes. Congress is going to be involved in any really big matter, and that's got to be dealt with. That deserves more attention, I think, in all of these matters. I will tell you, I testified with Ken Salazar about 20 times, literally, in the summer of 2010, when we're trying to plug that oil leak. We're hauled up to Congress. They want to be involved. And even though Restore Act is really a crappy piece of legislation, it was good that Mary Landrieu had the chance to put her stamp on it, and others did. They felt involved and vindicated to some extent. Final thing I'll say is the public accountability piece that was mentioned in this last panel and that John mentioned earlier, the notion that, and lawyers are bad at this, I think. They don't always realize that you can have the best legal settlement you think in the world, but if you didn't socialize it, and this is the Congress piece too, I think, if you didn't sort of reach out and bring in others, it may not stick. And if you did, you're more likely to have it stick. Anyway, we got our hands full now, thanks to all of you. Holy cow, I said we'll have a report in a year. We will. It could be 10 years, but we're going to shoot for a year. Thank you all for attending and making this a great day.